You step out of your front door, right? And you look down at the pavement or, the grass or the dirt beneath your feet, and you just think you understand how the world works.
You think you own it.
Exactly. You think, like, I bought this, I have a mortgage, I have a piece of paper in a filing cabinet somewhere. This slice of the planet, this exact GPS coordinate belongs to me.
Right. It feels permanent.
It feels absolutely like gravity, But if you actually dig into the legal bedrock of property, if you look at how courts and governments actually define what that dirt is, that sense of permanence completely crumbles.
It evaporates.
Yeah, you start to realize that property isn't a physical thing at all. It's a highly fragile, constantly shifting negotiation between you, your neighbors, and the overwhelming power of the state.
It is entirely an illusion of permanence. We walk around, believing in this simple binary concept. It's mine or it's yours. But the legal reality is this incredibly complex web of conditions, historical caveats, sovereign rights, things that can fundamentally alter who owns what.
And it changes depending on the wildest things, like whether you find gold in the soil or whether you die without a will.
Or if the government just decides your living room is the perfect spot for a new highway.
Exactly. And to understand how this machinery actually works, we are turning to one of the most, rapidly evolving legal landscapes on Earth today, which is India.
Specifically, we're going to be looking through the lens of Indian constitutional law and the specific statutes of Telangana.
Right. And to guide us through this deep dive, you are essentially stepping into the role of an honorary law professor at Osmania University today.
I will do my best to wear the tweed jacket, yeah.
Because, honestly, decoding centuries of legal evolution from British colonial administration to the dismantling of feudal landlords, all the way to modern urban sprawl, it requires a masterclass.
It's a massive syllabus.
It is. We have a stack of source material from an LLB study guide, heavily focused on Indian case laws, because the mechanics of how India handles property rights, eminent domain, and the protection of vulnerable communities, those are the exact same mechanics operating quietly under the floorboards of wherever you happen to be listening from right now.
They really are. If you want to diagnose the true values of a society, you don't look at its political speeches. You just don't.
No.
You look at its land laws. You look at how it distributes its most finite, essential resource. Because every single legal ruling about a plot of land is, at its core, a ruling about power.
And just a quick note for you listening before we jump in. We are going to be talking a lot about wealth redistribution, agrarian reforms, government policy.
Highly charged topics.
Very.
Yep.
But we're just looking at the legal mechanics here. We're not taking political sides. We're just unpacking the case law and the historical facts from the syllabus to see how the system functions.
Just the letter of the law.
Right. So let's start by dissecting the biggest illusion of all, the idea of absolute ownership. Under the law, what does it actually mean to have the ultimate, platinum tier claim to a piece of property?
Well, the foundational text we have to look at here is the Transfer of Property Act of 1882.
Okay, 1882. So we're dealing with a framework built during the British Raj.
Exactly. And under this act, absolute ownership is, theoretically at least, the highest form of property right. And it carries three distinct pillars.
Okay, what are the pillars?
First, you have the right to exclusive possession and enjoyment. So you can build on it, you can farm it, or you can just let it sit there and do nothing.
Right, that's pillar one.
Second, you have the unrestricted right of disposition, meaning you can sell it, mortgage it, lease it out, or, leave it to your kids.
Makes sense.
And third, and this is the most important one for later, it has perpetual duration. Your rights don't just expire after a set term like a 50-year lease.
Okay. And when you look at state-specific applications of this, like the Telangana Rights in Land and Pattadar Passbooks Act of 1971, they really see the modern bureaucratic machinery trying to codify that exact absolute ownership.
Yes. That act introduces the concept of the Pattadar,
which is the recognized landowner, right?
And the Patta, which is essentially the ultimate title deed. It is the physical manifestation of that 1882 absolute right. It
is literally a passbook.
It is. And the courts, they treat this little book with immense gravity. Look at the Supreme Court case, State of Punjab v. Raja Singh.
What happened there?
The justices were dealing with a massive dispute over who actually held the rights to a property. And the court ruled that these pattas, these official revenue records, they are not just helpful documents, they are conclusive evidence of ownership.
Conclusive, meaning they are the legal anchor.
Exactly.
Which means if I show up to court, right, and I have my title deed of my Patta, the burden of proof is entirely on whoever is trying to challenge me.
Precisely. And there's another major case, Satyapalanan, where the Supreme Court reinforces even further. They said that if you are claiming title to a piece of land, you cannot rely on, verbal agreements or historical use.
Like, oh, my grandfather farmed this for 20 years.
Right, that doesn't cut it. You must produce the registered title deeds. The written, state-sanctioned document is supreme.
But absolute ownership only means something if you can actually defend it, right? I mean, if someone builds a fence onto my property or just sets up camp in my backyard, how strong is that piece of paper?
It is a formidable shield. The Andhra Pradesh High Court dealt with this directly in Raja of Babali v. Venkatapaya.
Yep.
They looked at the inviolability of these rights, and the court stated in very unambiguous terms that any infringement upon absolute ownership without lawful authority is strictly illegal.
So the owner can just fight back.
Yes, the owner has the absolute right to repel interference.
And the Bombay High Court took a pretty similar stance too, right, in Shugrabi v. Koyali, focusing on eviction.
They did. In Shugrabi, the court affirmed that an absolute owner has an unquestionable right to evict unauthorized occupants or encroachers.
So you don't have to tolerate someone slowly eating away at your boundaries.
No, not at all. Your ownership gives you the power to clear the land of anyone who doesn't have a competing legal right.
Okay, so that establishes the fortress. My Patta protects me against my neighbors, against squatters, against, anyone trying to take my slice of the pie.
Right.
But let's look at the limitations. Because earlier you said ownership is an illusion.
It is.
So let's look at the Supreme Court case date of Tamil Nadu v. Hindstone. The ruling there affirms that absolute ownership includes the right to natural resources.
Yes, generally speaking.
So if I am digging a well on my legally owned land, right, and I strike a massive vein of gold, or like a reservoir of oil, does that absolute right mean I am suddenly a mining baron?
Well, this is where the fortress walls start to look transparent. The Hindstone case is fascinating because it seems to hand you the keys to the kingdom, but it actually reveals the invisible hand of the state.
How so?
Yes. The court affirmed that ownership generally includes the benefits arising from the land. But, and this is the critical caveat that applies in India, the UK, the US, and honestly almost everywhere else, that right is superseded by the sovereign reservation of subsurface minerals.
Wait. So the state lets me own the dirt but keeps the treasure?
Essentially, yes. The legal architecture splits the earth horizontally. You have absolute ownership of the surface. You can grow whatever crops you want. You can build a house.
Right.
But the state holds the subsurface wealth in trust for the entire nation. So if you find gold, coal, uranium, whatever, you do not own it.
Wow.
The state has the statutory authority to step in, claim the resource, and usually they will grant mining leases to extract it. Your absolute ownership stops a few feet below the grass.
That significantly redefines the word absolute. I mean, it's absolute on a two-dimensional plane, but definitely not a three-dimensional one.
Exactly.
What of the timeline, then? You mentioned perpetual duration earlier. The idea that my ownership outlives me.
Right, the third pillar.
What happens if a landowner passes away, but they leave no will, and they have absolutely zero surviving family members?
Oh.
The perpetual timeline is completely severed. So who gets the land?
This triggers one of the oldest legal mechanisms in property law. It's called the Doctrine of Escheat. And it's tied to the principle of Bona Vacantia, which roughly translates to ownerless goods.
Ownerless goods.
Yeah. Under Section 11110 of the Transfer of Property Act and certain sections of the Indian Succession Act, property cannot legally exist without an owner. It's like anathema to the legal system. A paradox.
Because ownerless land is a hazard, right?
Yeah.
I mean, it becomes overgrown, taxes aren't paid, it becomes a literal liability to the community.
Exactly. So the law steps in. It's very much like a game of Monopoly.
Okay, I love a Monopoly analogy.
Well, think about it. When a player goes completely bankrupt and is eliminated from the game, their properties don't just stay on the board in some neutral state.
Right, they revert back to the bank.
Exactly. In the real world, the state is the bank. It is the ultimate heir.
But how does the court justify the state just absorbing private wealth like that?
The Supreme Court articulated the philosophy perfectly in State of Maharashtra v. Narayan Shamrao. The court clarified there that escheat is not a penalty, The state isn't punishing the deceased.
Right.
It is an administrative necessity. When there is a complete and utter failure of heirs, the state absorbs the property to ensure it continues to serve a productive function in society.
And the Madras High Court echoed that, didn't they?
Yeah.
In Kumaravilu Chettiar v. Satasavem Chettiar.
They did, and they focused heavily on the public interest aspect. The court reasoned that allowing property to just lie idle and decay serves absolutely no one.
Right.
By reverting to the state, the property can be auctioned off or repurposed for public infrastructure or distributed to the needy. The state essentially acts as the steward of last resort.
Let's scale that concept up, though. Because absorbing one house when someone dies is one thing.
Yeah.
But the legal history of Telangana involves Escheat on an almost unimaginable scale.
Oh, absolutely.
I'm looking at the Telangana state's abolition and conversion into Ryotwari Act of 1950. The newly independent Indian government didn't just wait for people to die. They abolished entire feudal systems.
This is the massive, tectonic shift in Indian land law. To understand it, you really have to look at the colonial revenue systems that they were tearing down.
Okay, set the scene for us.
So the British administered land primarily through two opposing systems, the Zamindari system and the Ryotwari system. The Zamindari system was brutally feudal.
The British essentially outsourced their tax collection.
Yes, they recognized these massive landlords, the Zamindars, as the absolute owners of vast territories, villages upon villages. And the actual farmers, the peasants working the soil, had zero ownership rights. They were just tenants at will. The Zamindar extracted exorbitant rents from them, kept a massive profit for himself, and passed a fixed revenue share up to the British Crown. The tillers were completely trapped in generational poverty.
And the Ryotwari system was the alternative.
Yes, primarily implemented in regions like the Madras Presidency, which historically influenced parts of modern Telangana. The Ryotwari system basically cut out the middleman.
Okay.
The colonial government made a direct settlement with the individual cultivator, who they called the ryot.
So the farmer actually owned the land they worked?
They gained a recognized occupancy, yes.
Yeah.
It wasn't purely benevolent. The British did it because they realized Zamindars were keeping way too much of the profit.
Oh, of course.
A direct tax relationship was just more lucrative for the crown. But legally, it completely transformed the peasant from a serf into a recognized landholder.
That's a huge shift.
The Privy Council, which was the highest court during the colonial era, analyzed this in Collector of Godavari v. Seth and Arindas. They validated the Ryotwari settlement, highlighting how bypassing intermediaries completely changed the legal relationship between the individual and the state.
So fast forward to 1947. India gains independence. The new democratic government looks at these massive, exploitative Zamindari estates and decides, they cannot exist in a modern republic.
Right. They looked at the Constitution, specifically Article 39B and C of the Directive Principles of State Policy.
What do those clauses say?
They mandate that the state must direct its policy towards securing that the ownership and control of the material resources of the community are distributed as best to subserve the common good.
The common good.
Yes. It explicitly demands the prevention of the concentration of wealth.
Right. You cannot have a functioning democracy if 90% of the land is owned by 1% of the population who act like feudal lords.
Exactly. So the government initiated this massive wave of agrarian reforms, culminating in acts like the Zamindari Abolition Act. They legally extinguished the rights of the intermediaries.
Just wiped them out.
Yes. And as you can imagine, the Zamindars did not surrender their empires quietly.
Obviously not. I assume they took the government straight to court, claiming their absolute ownership was being violated.
It led to some of the most ferocious constitutional battles in Indian history. The landlords argued that the state was violating their fundamental right to property.
Right.
But the Supreme Court, in these monumental rulings, most notably building up to the philosophy seen in Kesavananda Paradivi's State of Kerala, they upheld the agrarian reform laws.
Okay, so the state won.
They did. The courts ruled that individual property rights must yield to the broader constitutional mandate of socioeconomic justice. The state had the legal power to forcibly dismantle feudalism.
This brings up a really thorny category of land ownership, though. We see the term Inam land pop up a lot in these sources.
Yes, Inam lands.
If a zamindar is essentially a tax collector, what is an Inam? Because taking back a massive corporate estate is one thing, but taking back a literal gift seems legally complicated.
It is. Inam is an Arabic word meaning gift or reward. Historically, pre-colonial rulers, like the Nizam of Hyderabad and later even the British, would grant Inam lands to individuals.
As a reward for what?
It could be a reward for military valor, a grant to sustain a religious institution like a temple or a mosque, or simply, a royal favor to a loyal courtier. And these lands were often totally tax exempt.
Okay, so it's the 1950s. A newly democratic government is looking at a family who has held a tax-free estate for 200 years just because a king liked their great-grandfather.
Exactly. And the new government passed laws like the Telangana Inams Abolition Act of 1956.
The logic being similar to the Zamindars.
Identical logic. These were privileged feudal tenures that locked up valuable land and exploited the subtenants who were actually working on them. So the state moved to abolish the Inams, take the land back, and issue Ryotwari titles to the actual working tenants.
But I imagine the Inam holders argued that a modern parliament couldn't just casually revoke a centuries-old royal decree. I mean, that's their heritage.
They fought it bitterly. They relied on ancient custom and personal law. But the Andhra Pradesh High Court delivered a definitive blow in Raghunatharav v. Venkatarayulu.
What did the court say?
The court ruled that modern, democratically enacted agrarian reform statutes completely override ancient customs, royal grants, and personal law.
Wow. Complete override.
The legislative intent to modernize the agrarian economy and achieve social justice was supreme. The royal gifts were legally erased.
So the state takes the land from the lords and gives it to the tillers. But, it wasn't an instant overnight transition. The law had to create a bridge for the people actually working the soil.
Right, it was a process.
So how did the courts define the rights of the people who didn't own the land but sweated over it every single day?
Well, the law recognized different tiers of vulnerability. The base level is the cultivating tenant.
Okay.
This is someone who leases the land, pays rent in cash or crops, and works it. Historically, they lived in constant terror of eviction.
Because they had no security.
None. The landlord could wake up one morning, decide they wanted the land back, and just throw the tenant off.
To fix that, the state created a new legal shield.
All right.
The protected tenant.
Yep. Yes. Through legislation like the Telangana Tenancy and Agricultural Lands Act of 1950, the state intervened heavily in private contracts. If a tenant had been cultivating a specific piece of land continuously for a set number of years, the law automatically upgraded them to a protected tenant.
And what does that upgrade actually get them in practice?
It fundamentally altered the power dynamic. A protected tenant gained statutory security of tenure. The landlord could no longer evict them on a whim.
So eviction was off the table.
Eviction could only happen under incredibly strict, narrowly defined circumstances, like failing to pay rent for consecutive years or actively destroying the land. Furthermore, the law often gave protected tenants the right of first refusal to purchase the land.
Oh, why?
And sometimes at prices set by the government, not the landlord.
But how did the courts handle landlords who, let's be real, we're definitely trying to find loopholes to kick these protected tenants out?
The judiciary came down like a hammer in defense of the tenants. In V. Satyanarayana v. State of AP, the Supreme Court made it clear that the statutory rights of a protected tenant are paramount.
Okay.
A landlord cannot bypass the strict provisions of the Tenancy Act through clever legal maneuvering. And in Guruvayur Devaswam Managing Committee V.C. Narayanan, the court affirmed that tenants have an absolute right to challenge any termination of their tenancy.
So the law effectively tied the landlord's hands to prevent the historical abuses of power.
Exactly.
That covers private tenancy. But there's another mechanism here where the state doesn't just regulate the landlord, it becomes the provider. I want to talk about assigned lands.
Yeah.
Because this seems like one of the most direct forms of social engineering in the entire legal framework.
Assigned lands represent the sharpest edge of the state's poverty alleviation strategy. The government basically identifies landless, impoverished citizens, often agricultural laborers or marginalized communities, and directly assigns them a parcel of government-owned land.
Or surplus land acquired through the Sealing Acts, right?
Exactly, which we'll discuss later.
It sounds like a pure social good.
Sure.
You give a poor family a plot of land to farm, and you break the cycle of poverty.
That is the intent, but the state understands the predatory nature of the real estate market.
Right.
If you give a desperately poor person an asset worth hundreds of thousands of rupees, what happens the moment someone in their family gets sick or they face a bad harvest?
A wealthy landowner or a corporate speculator swoops in, offers them a fraction of the land's value in immediate cash, and buys it.
And then the poor person is landless again, the state's resource is gone, and the wealthy speculator has just expanded their holdings.
It defeats the whole purpose.
Exactly. So to prevent this, the government enacted laws like the Telangana Assigned Lands Prohibition of Transfer Act of 1977.
And what does that do?
The assignment comes with an ironclad condition. The land is completely inalienable.
Meaning it cannot be transferred under any circumstances.
You cannot sell it, you cannot mortgage it to a bank, you cannot gift it. It is yours to cultivate, and it can pass to your direct heirs, but it cannot enter the open market.
Let's ground this in a real human dilemma, because when you read the legal case studies on this, the rigidity of the law clashes violently with human empathy.
It really does.
Let's imagine a landless farmer. We'll call him A. The government assigns him 2 acres. He farms it for 10 years. He survives, but he doesn't get rich.
Right.
Then his daughter is of marriageable age. In his community, funding this marriage is a massive social and financial obligation, but he has no savings. The only asset he has is those 2 acres.
Yes.
So he decides to sell 1 acre to a willing buyer to pay for the wedding.
From a purely human perspective, you understand his desperation. He is trying to utilize his only asset to fulfill a major life event. But from a legal perspective, he has crossed a fatal line.
But if that sale is challenged in court, does the judge have the discretion to say, look, it was for a family emergency, we'll allow it?
No. The courts have been utterly uncompromising on this. The Supreme Court addressed this exact tension in State of Maharashtra v. Salamat Khan.
And what was the verdict?
The justices acknowledged the personal hardships, but they ruled that the statutory prohibition on transferring assigned lands is absolute.
Absolutely. No exceptions.
Right, because the law's purpose is to protect the vulnerable class as a whole from entering into exploitative transactions driven by temporary desperation.
And in Narayan Rao v. State of AP, the court ruled on the status of that transaction itself, right?
They did. The court held that any sale of assigned land is void ab initio.
Which mean?
It means it is legally null and void from the moment the ink dries. It never happened in the eyes of the law.
So what happens to the farmer? And what happens to the buyer who gave him the cash?
This is where the state's power of resumption kicks in.
Resumption?
Because the farmer violated the core condition of the assignment, the state government initiates proceedings to cancel the patta entirely. They resume the land, meaning the state takes it back into its own inventory.
Oh, wow. So the farmer loses the land entirely?
Yes. And the buyer loses the land and the money because they engaged in an illegal transaction. The law prioritizes the systemic integrity of the social welfare program over the individual's immediate crisis.
It is a harsh, almost paternalistic mechanism.
It is, but it's designed to force the land to remain a long-term agricultural asset rather than a liquid emergency fund.
That is a brutal reality check on what ownership means when the state is the one doing the giving. The strings attached are made of steel.
They are.
But let's flip the dynamic. We've talked about the state giving land away. Let's talk about the state taking it by force.
Ah, yes.
This brings us to the 2 most terrifying and honestly essential powers of any government: police power and eminent domain.
To live in a civilized society, you have to accept that your absolute ownership is subordinate to the collective survival of the community. The state wields 2 distinct instruments to enforce this. The first is police power.
Now, the way I think about police power is that it's regulatory. It's the state acting as the ultimate referee. So if I own a 5-acre plot in a quiet residential suburb, my absolute ownership might make me think I can build a massive toxic chemical processing plant right there on it.
Right.
Police power is the state stepping in with zoning laws and environmental regulations, saying, no, you can't build that here because the fumes will poison your neighbors.
That is exactly right. Police power is the inherent authority of the sovereign to restrict the use of private property to protect public health, safety, morals, and general welfare.
But I still own it.
Yes, you still hold the title deed, you still own the land, but your freedom to use it however you want is curtailed. And crucially, because the state hasn't actually taken the land from you, they do not owe you compensation for telling you not to build a toxic factory.
Got it. But eminent domain is a completely different animal.
Eminent domain or compulsory acquisition is expropriation. This is the state saying, we don't just want to regulate your land, we need your land.
They forcibly take it.
The state forcibly extinguishes your title, takes the property, and utilizes it for a public project. Because this is a permanent deprivation of your fundamental right to property, the Constitution demands that the state must pay you compensation.
The line between those 2 powers, though, Seems like it could get blurry very quickly, especially when you're dealing with massive industries.
Very blurry.
Look at the Supreme Court case. Mysore Minerals Ltd v. State of AP. How did the court untangle regulation from seizure there?
It was a brilliant delineation by the court. So imagine a company owns land rich in minerals. The government passes a law saying, to protect the local watershed and prevent massive soil erosion, you can only mine 10 tons of ore per month, and you must plant trees around the perimeter.
Okay, sounds like regulation.
Right, but the mining company sues, claiming the government has effectively taken their property by restricting their profits, and they demand compensation.
Because they can't mine as much as they want, but the court says no.
Exactly. The Supreme Court ruled that this is a classic exercise of police power. The state is regulating the manner of extraction to protect the environment. The company still owns the land and the ore.
Right.
However, if the government passed a law saying, this specific mineral is vital for national defense, so we are taking over the entire mine, kicking your company out, and the state will mine it directly, that crosses the line into eminent domain.
Because the title transfers.
Yes.
Yeah.
And compensation becomes constitutionally mandatory.
And for a more everyday example of eminent domain, we look at urban infrastructure, right? Like in the municipal core of Greater Mumbai v. Indian Oil.
Exactly. The city of Mumbai is choking on traffic. The municipal corporation decides they need to widen a major arterial road.
A tale as old as time.
To do that, they have to slice 10 feet off the front yards of 50 privately owned properties, including land owned by Indian Oil. The court affirmed that acquiring private land to ease traffic congestion and improve public safety is a textbook, unassailable exercise of eminent domain.
Which hinges entirely on the phrase public purpose. If the state is going to forcibly evict you, it has to be for the public good. Building a road, a hospital, those make sense.
Right.
But what if the government uses eminent domain to seize my family farm and then hands that land over to a massive private tech company to build a server farm, claiming that the new corporate jobs will benefit the local economy? Is that still a public purpose?
This is the bloodiest battlefield in land acquisition law.
I bet.
For over a century, land seizure in India was governed by the Land Acquisition Act of 1894. This was a colonial law designed to build railways and extract resources rapidly. Under the 1894 Act, the government's power to declare something a public purpose was almost dictatorial.
If they said it, it was true.
Exactly. If the state gazette said it was for a public purpose, the courts were highly reluctant to question it.
Which led to massive abuses, I'm sure. The state essentially acting as a real estate broker for private corporations.
Oh, rampant abuses. The state would acquire land at cheap agricultural rates using the threat of force and then just transfer it to industrial houses. The courts recognized the danger. In 1954, in State of West Bengal v. Bela Banerjee, the Supreme Court tried to draw a line.
What did they do?
They ruled that if the state acquires land for a company, the underlying project must serve a genuine public purpose that benefits the community at large. It cannot be a thinly veiled mechanism to boost a private corporation's profit margins.
And they had to keep fighting that battle for decades. Indoor Development Authority v. Manohar Lal tackled the exact same issue.
Yes, reinforcing that the core intent of eminent domain cannot be commercial speculation by the state or its private partners, but the real paradigm shift didn't come from the courts.
Where did it come from?
It came from the legislature, because the unrest over the 1894 Act reached a boiling point across the country. Farmers were losing their ancestral lands and receiving pennies on the dollar, while corporations built luxury townships.
So how do you calculate the price of a forced eviction? I mean, if the state says we are taking your home for a highway, how does the law determine what that trauma is worth?
Well, under the old 1894 system, compensation was a cold mathematical calculation. Article 300A of the Constitution guarantees that you cannot be deprived of property without authority of law, which implies compensation.
Yeah.
In Union of India v. Raghuveer Singh, the Supreme Court established the standard formula. Compensation was based on the market value of the land on the specific date the government published the preliminary notification of their intent to acquire it.
But market value is a terrible metric for a forced sale.
It is.
I mean, if I have a willing buyer and I'm a willing seller, market value works perfectly. But if a farmer's family has lived on a plot of land for 300 years, the quote-unquote market value of that dirt does not factor in the loss of their community, their generational livelihood, their proximity to their local temple, and, the sheer psychological trauma of being displaced by bulldozers.
You have articulated the exact moral failure of the 1894 Act. Market value is an economic metric, not a human one. The judiciary began to realize that forced acquisition was creating a massive underclass of displaced, impoverished people. In Jairam v. State of Haryana, the Supreme Court explicitly stated that the land acquisition process must be guided by the constitutional principle of distributive justice.
What does that mean in practice?
It means the state's push for infrastructure cannot be subsidized by the deliberate impoverishment of the landowners.
So in 2013, the Indian Parliament finally threw out the 1894 colonial law and replaced it with a massive modern framework.
Yes.
The right to fair compensation and transparency in Land Acquisition, Rehabilitation, and Resettlement Act, the RFCTLARR Act.
It is arguably one of the most progressive land laws globally because it attempts to codify that human element you just described.
How does it redefine the math?
First, it doesn't just pay market value. It often mandates paying 2 to 4 times the market value depending on whether the land is rural or urban.
That's a big jump. But more importantly, it stops treating it as just a real estate transaction, right? It introduces mandatory rehabilitation to resettlement, or R&R.
Exactly. If the state displaces a village to build a dam, they can't just hand out checks and walk away anymore. The 2013 Act legally obligates the state to rebuild that community.
Rebuild it how?
They have to provide alternative housing. They have to guarantee employment for at least one member of every affected family or provide a lifelong annuity. They have to build new schools and new infrastructure at the resettlement site.
And before they even break ground, the new law introduces a procedural hurdle that fundamentally shifts the power dynamic. The social impact assessment, the SIA. How does that actually work?
Under the old law, the government decided to build a project, published a notice, and that was it. Under the 2013 Act, before the acquisition process can truly begin, the government must commission an independent social impact assessment.
Who does the assessment?
Teams of sociologists, environmentalists, and local representatives go into the community. They don't just measure the acreage, they measure the human fabric.
They ask the hard questions.
They calculate how many families will lose their primary source of income. They assess the impact on marginalized laborers who don't own the land but work on it.
Right, because they lose their jobs too.
Exactly. They evaluate the environmental degradation, they assess the disruption to local culture, and crucially, and this is huge, if the SIA concludes that the social costs and the human suffering outweigh the projected public benefits of the project, the acquisition can theoretically be halted.
It forces the state to put the trauma on a spreadsheet right next to the profit projections.
Yeah.
That is a massive leap from the colonial extraction mindset.
A total paradigm shift.
It brings us to the final major theme of our deep dive. We've seen how the law redistributes land and how it seizes it. Now we need to look at how the law acts as an absolute fortress for the most vulnerable, and how it bends the rules of the Constitution to protect its own reforms.
Right.
Let's start with the fortress, scheduled areas and tribal rights.
If you look at the map of India, there are specific regions designated under the 5th schedule of the Constitution as scheduled areas. These are regions with historically high populations of indigenous tribal communities. And the legal physics in these areas operate completely differently than in the rest of the country.
Because historically, the free market has been an absolute engine of destruction for indigenous communities.
Absolutely. For centuries, tribal communities whose relationship with the land is often communal and deeply intertwined with their spiritual and cultural identity were systematically exploited by non-tribal settlers, moneylenders, and corporations.
It's completely taken advantage of.
They would be trapped in predatory debt cycles, and their ancestral lands would be seized through fraudulent contracts or simple coercion. To halt this eradication, the Constitution framers created the 5th schedule to act as an impermeable legal membrane.
And states enacted specific laws to enforce it, like the Andhra Pradesh Scheduled Areas Land Transfer Regulation Act of 1959.
Yes.
What does that law actually say?
It implements a total, uncompromising prohibition on the transfer of land in scheduled areas from a tribal person to a non-tribal person.
Period.
Period. You cannot sell it to an outsider. You cannot lease it to an outsider. Even if a tribal landowner genuinely wants to sell their land to a wealthy developer from the city, the law forbids it.
This prohibition led to one of the most explosive landmark judgments in Indian environmental and constitutional law, the Samathavi State of AP case in 1997. Set the stage for us. What happened?
Deep in the scheduled areas of Andhra Pradesh, the state government identified massive deposits of valuable minerals.
Okay, so the state seized dollar signs.
Naturally, the government, acting on its sovereign right to subsurface wealth, which we talked about earlier, decided to grant mining leases to several large non-tribal private corporations.
But wait, the law says land in a scheduled area cannot be transferred to a non-tribal person.
This is where the state attempted a breathtaking piece of legal gymnastics.
Oh boy.
The government argued the law prevents a tribal citizen from selling to a non-tribal citizen, but we are not a citizen, we are the state government.
They tried to exempt themselves.
Exactly. They said, the mineral-bearing land belongs to the state. The word person in the Prohibition Act does not apply to the sovereign state. Therefore, we are immune from the Fifth Schedule, and we can lease this land to private mining companies for the sake of economic development.
They tried to argue that the government itself was a loophole.
An NGO called Samatha took the government to court, and the Supreme Court delivered a verdict that sent absolute shockwaves through the industrial sector.
What did they rule?
The court engaged in a deep, purposive interpretation of the Constitution. They ruled that in the context of the Fifth Schedule, the word person absolutely includes the state government.
Which means the government's hands are tied just like everyone else's.
Precisely. The court held that even the sovereign state is prohibited from transferring tribal land, whether by lease, sale, or any other means, to non-tribal private entities for mining or industrial purposes.
The Fifth Schedule is supreme.
Yes. The court declared that if mining was to happen in these ecologically and culturally sensitive areas, it could only be done by the state-owned mineral corporations themselves, or by cooperative societies composed exclusively of members of the scheduled tribes. Private, non-tribal corporations were completely locked out.
That is a staggering assertion of constitutional protection over raw capitalist development.
It really is.
And it wasn't a one-off. The courts reinforced this power even more dramatically in the Nyamgiri Suraksha Samiti case in 2013.
The Nyamgiri case is globally recognized as a triumph of indigenous rights. A massive multinational corporation, backed by the state government, planned to mine bauxite in the Nyamgiri Hills of Odisha.
Bauxite mining is incredibly destructive.
It is, and these hills are not just land. They are the sacred deity Nyamraja to the Dongria Khan tribe. The mining project would have physically destroyed the religious epicenter and displaced the entire community.
So how did the legal battle play out? Did the Supreme Court just cite the Samatha case and stop it?
They went further. They invoked the Forest Rights Act and decentralized the power completely. The Supreme Court ruled that the ultimate authority to decide the fate of the Nyamgiri Hills did not rest with the bureaucrats in the capital or even the judges in the Supreme Court.
Who did it rest with?
It rested with the Gram Sabha,
The Gram Sabha.
the local grassroots village councils made up of the adult members of the tribal community.
The court handed a veto power to the village itself.
Yes. The court mandated that the government must seek the free, prior, and informed consent of the Gram Sabhas before any environmental clearance could be granted.
And did they?
The Gram Sabhas held their votes. It was a true exercise of direct democracy, and all 12 village councils unanimously voted against the mine.
Wow.
The multi-billion-dollar project was scrapped. The law recognized that for indigenous communities, land is not a tradable commodity, it is existence itself.
Let's test this absolute protection with a hypothetical scenario from the syllabus. Say, the government of Telangana decides to lease a beautiful tract of land situated squarely inside a scheduled area to a non-tribal entrepreneur, let's call him A, to build an eco-resort.
Okay.
B, a tribal individual from the local village, files an objection in court. Who wins?
Based on the unyielding precedent of the Samatha judgment and the Fifth Schedule, B wins decisively.
Even though it's an eco-resort, not a mine.
The intent of the eco-resort doesn't matter. The economic promises don't matter. The lease executed by the government to A, a non-tribal, is legally void from its inception. The state cannot bypass the constitutional firewall. The court would strike down the lease and mandate that the government must consult with the tribal advisory councils or the Gram Sabha.
It is incredibly powerful to see the law act as an impenetrable shield like that. But if we shift our gaze from the remote, ancient hills to the exploding, hypermodern cities, we see the law acting much more like a sword.
We do.
Let's talk about the chaos of urban real estate, urban ceilings and land grabbing.
As India industrialized, cities like Hyderabad exploded in population and wealth. But the real estate market was fiercely monopolized. Just as a few Zamindars used to control the countryside, a tiny elite of wealthy families and speculators were hoarding vast tracts of prime urban land.
Leaving the growing middle class and the poor with nowhere to live.
Exactly. So the state brought the logic of the agrarian reforms into the city.
They enacted the Urban Land Sealing and Regulation Act of 1976.
Right. The state essentially declared a maximum limit on how much vacant land a single individual or entity could own within an urban agglomeration.
So if you owned 50 acres of prime city real estate,
The law might say you're only allowed to keep 2 acres.
then the rest.
The rest was declared surplus. The state acquired it with minimal compensation used for public housing, infrastructure, or to distribute to the urban poor.
I'm sure that went over well with the elite.
Oh, they fought it. But the Supreme Court backed this aggressive redistribution in Prem Nath Kapoor v. State of Haryana. The court clarified that the act was a direct implementation of the constitutional directive to prevent the concentration of wealth. It was designed to choke off the speculative hoarding that artificially inflated land prices and crippled urban development.
But the concentration of wealth wasn't the only problem in the cities. The sheer value of urban land birthed a completely different crisis: organized crime.
Yeah. You have an entire section here dedicated to the Land Grabbing Prohibition Act.
Yes, in cities where a single acre can be worth millions of dollars, land grabbing became an absolute epidemic. We are not talking about a neighbor accidentally building a fence over your property line.
We're talking about mafias.
We are talking about organized syndicates, often backed by political muscle or forged documents, violently seizing public lands, lakes, or private plots belonging to vulnerable individuals who couldn't fight back. Why couldn't the police or the normal courts just handle it? I mean, if someone steals your car, you call the cops. If someone steals your land, shouldn't it be the same?
The problem was the paralyzing speed of the Indian civil justice system. If a mafia grabbed your land and you filed a civil suit, it could take 20 years for the courts to unravel the forged documents and issue an eviction order.
20 years.
And by that time, the grabbers had built an apartment complex on your land and sold the units. The normal courts were totally ineffective against the speed and audacity of organized land mafias.
So the state of Telangana had to forge a specialized weapon.
They enacted the Telangana Land Grabbing Prohibition Act. This legislation bypassed the sluggish civil courts entirely by establishing dedicated land-grabbing tribunals and special courts.
Special courts.
Yes, and these special courts were given extraordinary powers.
Like what?
They functioned with the combined powers of a civil court and a criminal court. They could conduct rapid, specialized investigations. If they found you guilty of land grabbing, they didn't just order you to leave. They could impose severe criminal sentences, including long-term imprisonment.
Wow.
And mandate the immediate physical restoration of the land to the rightful owner.
I assume the people accused of land grabbing immediately sued, claiming the special courts violated their right to a standard trial.
They did. But in Pinor Samarao v. State of AP, the High Court upheld the constitutional validity of these draconian anti-grabbing laws. The judiciary recognized that the cancer of land grabbing was an existential threat to urban stability. Extraordinary crimes against the land tenure system required extraordinary, streamlined judicial mechanisms.
Okay, Professor, as we reach the culmination of this deep dive, I need to ask you about a glaring historical paradox that has been running underneath every single law we've discussed today.
Okay, what's that?
We've talked about abolishing zamindars, seizing surplus agricultural land, taking surplus urban land, and enforcing tenancy laws. Every single time the government passed one of these massive redistributive reforms, the wealthy elites sued,
Yes.
claiming their fundamental constitutional rights, specifically the right to property, were being violated. If the courts are designed to protect fundamental rights, how did the government ever actually enforce these reforms? Wouldn't the Supreme Court just strike them down?
You have put your finger on the exact constitutional crisis that nearly tore the Indian Republic apart in its early decades.
Really?
Yes. And the answer to your question is one of the most audacious legal maneuvers in modern democratic history. You are entirely correct. The government would pass a land reform act. The landlords would immediately challenge it under Article 31, the fundamental right to property.
Right.
The high courts, strictly interpreting the Constitution, would strike the reform laws down. The government's entire socioeconomic agenda was completely paralyzed.
So how did the Parliament break the judicial deadlock?
They realized they couldn't win the game with the current rules, so they rewrote the rules.
They rewrote the rules.
In 1951, the Parliament passed the First Amendment to the Indian Constitution. This amendment birthed a mechanism known as the IX Schedule, and it was tied to a new clause, Article 31B.
I call this the constitutional cheat code. How did it work?
The mechanics of the IX Schedule were breathtakingly authoritarian in their simplicity. The amendment stated that any law placed by Parliament inside the IX Schedule becomes absolutely immune from judicial review on the grounds that it violates fundamental rights.
Wait, so the government could pass a law that clearly violated a citizen's right to equality or their right to property, but as long as they dropped that law into the IX Schedule, the Supreme Court of India was legally blind to it. They couldn't strike it down.
Exactly. It was a constitutional vault. You put all law inside, lock the heavy steel door, and the judiciary is locked out.
That's wild.
The government immediately took the Zamindari Abolition Acts, the Tenancy Acts, the land sealing laws, and dumped them by the dozens into the IX Schedule. It was a massive blunt force sword used by the state to ram its socialist agrarian reforms through against the entrenched resistance of the elite.
That is a terrifying amount of power for a legislature to have.
Yeah.
I mean, what stops them from putting censorship laws or election rigging laws into the IX Schedule? Surely the Supreme Court didn't just quietly accept that a huge chunk of the Constitution had been cordoned off.
The Supreme Court watched with growing alarm as the IX Schedule swelled from a handful of land laws to dozens and eventually hundreds of acts. They realized that an unchecked power to immunize laws from judicial review could allow a tyrannical parliament to dismantle the democracy from within.
Yeah.
The tension built for 20 years, culminating in 1973 in what is universally regarded as the most important constitutional case in Indian history, case of Anandharati v. State of Kerala.
A case we touched on earlier regarding agrarian reform, but the real legacy is what it did to the IX Schedule.
Yes. In case of Anandharati, a massive 13-judge bench sat down to decide the ultimate question. Does Parliament have unlimited power to amend the Constitution and hide laws in the IX Schedule?
And what did they decide?
By a razor-thin majority of 7-6, the court delivered a masterstroke. They invented the basic structure doctrine.
What does that mean?
The court ruled that yes, Parliament has broad powers to amend the Constitution, and yes, they can utilize the IX Schedule. However, Parliament does not have the power to alter, destroy, or abrogate the basic structure or essential features of the Constitution.
Essential features like what?
Things like democracy, secularism, the rule of law, and judicial review itself are part of the basic structure. You cannot amend them out of existence.
So how does that affect the vault of the IX Schedule?
It picked the lock. The court ruled, and this was clarified in subsequent cases like I.R. Coelho, that laws placed in the IX Schedule are protected from general fundamental rights challenges.
Okay, so the land reforms are safe.
Yes, this allowed the historical land reforms to survive, which the court recognized as a socio-economic necessity. But if a law placed in the IX Schedule violates the basic structure of the Constitution, the immunity evaporates. The Supreme Court can strike it down.
They allowed the state to redistribute the land, but they drew a final line in the sand to ensure the state couldn't become a dictatorship in the process.
Precisely. It was a brilliant, precarious balancing act that saved the Indian Constitution while allowing the society to modernize its relationship with property.
Let's step back and look at the grand architecture we've explored over the last hour. We started by dismantling the illusion of absolute ownership, realizing that your title deed is ultimately subordinate to the state's escheat and subsurface rights.
Right.
We witnessed the historic demolition of feudal zamindars, replacing them with the rights of the tiller and the protected tenant. We explored the terrifying calculus of eminent domain and how the 2013 Act attempts to humanize forced evictions through social impact assessments. We saw the Fifth Schedule build an absolute fortress around tribal lands, and we watched the Supreme Court invent the basic structure doctrine to prevent the IX Schedule from destroying democracy.
When you look at it all together, you realize that land law is not a dry collection of statutes about dirt and boundaries. It is a living, breathing, and often violently contested record of a society's attempt to balance irreconcilable forces.
It really is.
It is the friction between absolute private wealth and urgent social equity. It is the battle between the relentless drive for industrial progress and the agonizing reality of human displacement. Every case law we discuss today is history permanently written into the soil.
And for you listening, I hope this changes how you view the physical world around you. Because the mechanics we unpack today aren't confined to textbooks or specific jurisdictions.
Not at all.
Wherever you live, similar battles are playing out under your feet. Zoning boards debating the limits of police power, city councils authorizing eminent domain for a new transit line, tenant unions fighting for eviction protections against corporate landlords. The legal scaffolding we explore today is the invisible matrix of your city.
It is the fundamental operating system of civilization.
Professor, before we close this deep dive, I want to ask you about the future. We've spent an hour talking about physical earth, agriculture, mining, highways, dirt. But the very definition of what constitutes property and land is undergoing a radical mutation, isn't it?
It is, and this is the frontier that keeps legal scholars awake at night.
I can imagine.
The magnificent legal frameworks we discussed today, the 1882 Transfer of Property Act, the limits of eminent domain, the Ryotwari Settlement, were engineered for physical dirt and stone. But look at the trajectory of the 21st century. We are accelerating into an era of sprawling data centers that require massive physical acreage just to process our digital lives. Simultaneously, corporations and individuals are spending millions of real dollars to purchase virtual real estate in digital spaces and the metaverse.
Right. If I drop $50,000 on a prime commercial plot in a virtual digital city, do I have absolute ownership under the law?
That is the defining question. If you own a digital plot, can the platform hosting that universe exercise a form of digital eminent domain and delete your property if they need to upgrade their servers or reroute digital traffic? Who compensates you?
Wow.
And returning to the physical world, we face an even more existential crisis. As climate change permanently alters coastlines and extreme heat renders vast tracts of agricultural land completely unviable, what happens to the laws of resumption and fair compensation when the land you legally own physically disappears beneath the ocean?
When the very nature of what constitutes land fundamentally changes, how do centuries of legal precedent adapt?
That is the next great legal battle. The rules of the game are about to change entirely, and the critical question remains. When the definition of land evolves, who will the law choose to protect next?
A profound and unsettling question to leave us with. When the legal machinery looks at the rapidly changing earth, what will it see? Thank you for joining us on this deep dive. Until next time, keep questioning the ground beneath your feet.